Off this Board of Adjustment study session for November 16th, and I'd like to start with Ms. McClellan.
Hello. Well, good evening, everyone. I'm going to start by introducing, I don't know that you have all had the opportunity to meet our relatively new city attorney, Steve Kemp. He has not come to any of our meetings, but Steve, this is the Board of Adjustment, and Steve has been with us since July.
Yes.
Excited to have him, so he's going to jump in and help me out with this training as we go along. So this is just a very basic training. We've given a pretty similar presentation to some of the other boards, and I'm going to try to keep it moving along.
Yes. Ask a question.
Yes.
A few months back, we had this kind of training with the prior temporary city attorney. What's going to be different in this one?
And with Ken Feldman?
Yes.
Yeah.
Yeah, it was kind of a general all boards and commissions.
Oh yeah, it was the one that we did with everybody, the generalized legal training with.
This is a little more tailored to them. It's a little bit more tailored.
To what you do. I mean, the city does sort of a general training that we talk about generally what the roles of boards and commissions are. But what we're doing with individual boards and commissions is really more of what is it that you do as a Board of Adjustment? What is your roles? What types of things in terms of how you handle things? You have different roles. You have some roles where you're a quasi-judicial body. You function much like a judge. You also have some other roles under the city code where you don't function as a quasi-judicial body. And really the whole purpose of this is just to spend a little bit of time talking about those, answering any questions you have, and really our goal is to help you have the background information so you can be the most effective board in whatever role you're wearing, or as I like to say, whatever hat you're wearing, you can be the most effective possible. And so that's what the intent is, and that's sort of how it differs from what Ken Feldman did.
And there will be a little bit of a recap of some of those same topics about how to handle public meeting, but because that's a fairly important topic, I think it's important to bring that back up just as a refresher course. And at any time, if you have any questions or you want some more detail about a particular topic, please ask us and let us know. I really would prefer this to be more of a conversation, and I don't really want to spend the evening lecturing you, so please ask questions as we go along. Okay. So we'll start by talking a little bit about your role as the Board of Adjustment. The Board of Adjustment powers and duties can be found specifically in the Littleton Municipal Code in section 2-3-1. It is a hefty paragraph, so I did not include every single thing that's in there, but I think it's worth a read if you haven't looked at it in a while. But some of the bigger things and the things that you see more on a regular basis are appeals and interpretations relating to Title 10 or the zoning code, requests for zoning ordinance variances, which is probably, I would say, the one that you see the most, and appeals and requests for variances to the sign code, and like I said, many more. Things like appeals to news racks, which I don't know if you realized was in there, but so there's a lot of different things in there, but these are the ones I felt were the things that you do on a more regular basis.
What's kind of unusual here in Littleton is, in most cities, what you would find your Board of Adjustment is really designed to handle matters arising under the land development codes, primarily the zoning code, and either grant variances or interpretations. We have a rather unusual code where there's actually parts of the building code that you can appeal to the Board of Adjustment. I have no idea why that is, other than that's what the code states right now. Also, if you're asked to remove a tree, where does the appeal of removing a tree come to? The Board of Adjustment. Again, that's highly unusual. I can't think of I've practiced law, this is the fourth state I've practiced law in. I've represented local governments my whole career. This is the first place I've ever come to where you get to appeal tree removal to the Board of Adjustment. So it is, that's just kind of unusual. Obviously, almost probably 90% of what you're going to do is always going to be related to land development. But there are actually other things in our code right now that you are responsible for.
Sewer tap fees.
Yeah, sewer tap fees is another one.
We've had one of those before. I did have a question on the building stuff, because there is the Building Board of Appeals as well.
And there is.
Go ahead.
What's kind of unusual about it is that you would find in most jurisdictions, everything pertaining to the building code goes to the Building Board of Appeals. We actually have some provisions within the international code that refers it going to the Building Board of Appeals, and in our city code, that refers it going to the Board of Adjustment, which from a lawyer's standpoint is absolutely a lawyer's nightmare when you're trying to figure out, okay, which board does it go to? And honestly, if you look at much of our city code, it was written in the 1970s. I don't think, at that time, the international codes didn't even exist. And many cities hadn't adopted the uniform codes. So probably, in all honesty, in 1970 when it was written, it made great sense because that was the only code. The trouble with it was, as other codes got adopted, no one ever sat back and said, let's look at this and figure out what we need to do to make it right and make the two pieces coexist properly. Actually, that's one of the things you're going to be seeing the city do over the next couple of years, is there's a number of these where you're going to actually see us go back, and we're going to do that. But so there's some very unique responsibilities. Hopefully, we won't be. You even have a couple of responsibilities under the city's floodplain code, which again, I don't know why that is there. Floodplain matters are usually, there's usually a floodplain board of appeals that has engineers and people familiar with that who would handle those. And it's those, but technically you still have those responsibilities. And obviously if we got one of those types of cases, we would work very closely with you in making sure you have all the information you need to properly deal with that type of case.
Is there an option if something like that were to come up? I mean, floodplains are highly technical items, that the board could defer the ruling to?
Technically, right now there isn't. What I would tell you is much more common, again, in most jurisdictions, is on some of these technical types of things, they actually use hearing officers. The hearing officer takes all the testimony, makes a report, and then the specialized board acts on that report. Again, that as we go through our codes over the next few months, and you're going to see some of those things that really exist elsewhere throughout this metro area, except here. You're going to see us move to some of those things, assuming that's where the council wants to from a public policy standpoint, just because my philosophy as the city's lawyer is the code needs to be workable. I can't think of anything worse to the citizens than to have a code that you either can't understand it or it doesn't work. To me, that's one of the things that gives government a really bad reputation is when people come in and they can't make, the code makes no sense. So we are working through those types of issues. We'll be working with all of the different boards because some of these issues impinge on different boards' responsibilities. So while you don't normally have a legislative role, don't be surprised if we come in and have a study session with you and say, we're looking at making this change. We want you to just be aware of it, even though it's technically not within your role.
Sounds to me as a result of this process, you're advocating additional boards for the city to handle more technical matters rather than relying on a small town, which is a relatively small town, relying on a small number of boards.
And I'm not, that would be something for council to decide, whether council wants to have more boards. I would tell you in most jurisdictions, probably the one board that you would see in most jurisdictions that we don't have here would be a floodplain board. That normally is something that you would see in most jurisdictions. But if council was to say we don't want to do that, we would rather find some other mechanism. That's council's prerogative, and the staff will make it work.
Well, it seems to me that this board in particular is really pretty much a citizens' input and citizens' board that in its common sense viewpoint of the world provides citizens' input into decisions and into the process, where other boards that you were mentioning just generally deal with bureaucrats and experts, and I think that's probably the salvation of the board as well as also the salvation of the community.
No, and I think that's the intent behind of a board of adjustment. If you look at and board of adjustments are not unique to this state. Most states have adopted what we call a Uniform Zoning Enabling Act, which is basically the foundation for zoning in roughly about 40 out of the 50 states, including Colorado. And essentially, if you were to look at that Uniform Zoning Enabling Act, it provides for a board of adjustment. And it envisions exactly what you talked about, a citizen board that can look at when the zoning code creates hardships and difficulties and look at how you can mitigate those. So that is the underlying intent. Whether you were here in Colorado, if you went down the road to Arizona, Arizona has a Uniform Zoning Enabling Act very similar to the Colorado Act. What does it have for in it? Board of Adjustment, just like the state does. If you were to go to the west of the state, to Utah, Utah has a Uniform Zoning Enabling Act. Same thing. And it is, all of those acts are very similar in that they envision this idea of a citizen board to mitigate sometimes the nature of the zoning code.
Any more questions relating to this slide? Yes?
Want to make the first slide?
Oh, there are more, don't worry. So just briefly talking about so we talked about your role as a board, touching on some of the roles of the other parties, role of city council in relation to your board. Obviously, city council is your local legislative authority. They're the ones that are ultimately setting any of the policies and laws relating to land use or any of the issues that you might see as a board. And they're going to be the ones that are going to adopt the sections of the city code that you would be looking at, and obviously they appoint the members of your board. So the role of staff, you guys see staff at every meeting. Your friendly neighborhood local community development staff is there to support you as part of their duties. A small snippet of the things that they do. They are responsible for processing and reviewing of the applications for appeals and variances that you might see. They schedule any of the meetings or hearings. They prepare the wonderful staff reports that you receive. They handle the meeting minutes and records, and they provide you other assistance as necessary. And then myself and by extension Steve are here to provide legal advice to staff regarding issues, and also to the board at the meetings, and to keep everybody in check.
Now, occasionally what you will see, and you saw it recently, we will be advising staff through the matter. And so we will have, sometimes we will have a contested matter where we've been advising staff, the applicant has a lawyer, and when we have that, we can't represent staff and represent you. There's a series of ethical rules for lawyers called the Rules of Professional Conduct, and if you ever want to come by and discuss them, we'll have a couple cups of coffee and we can talk about all of them. But what they basically say is that a lawyer cannot represent two clients with differing interests. So because we've been providing legal advice all the way through to staff, we can't suddenly toss staff to the winds and say, oh well, too bad, so sad, we're going to represent the board. Instead, what we would do in those cases is we will retain an outside counsel on the board's behalf to represent the board. They are your lawyer, they represent you, they give you their legal advice, we would give the staff our legal advice, but ethically we can't represent two clients. So if you're wondering, well, why recently there was one where Brandon Dittman represented you. And if you were wondering, well, why was that the case? Well, it was because we'd been advising staff, there was a lawyer involved, and there was now a matter in front of you. We can't wear two hats.
So I have a question on that. That was definitely a unique meeting. I've been on the board for, 7-8 years now. And I've never had a case like that, or at least when I was present. So in that case where we have an attorney representing us as the board, is it possible when those cases come up that we have basically a meeting with the attorney prior to the hearing? Or is that kind of against our rules and regs for the board?
No, you can certainly meet with them, but under the city charter in this city, you would have to meet in an open public meeting. Littleton has a charter provision which limits executive sessions, what we call executive sessions, closed sessions, to only two purposes. One of them is discussing information which is confidential under state or federal law, and two is discussion with a lawyer regarding actual litigation that has been filed in a court. And so, other than that, yes, we can always, when you have outside counsel, if the chair will let us know, we will connect the chair and the outside counsel together, and you can certainly meet with them. It does create some issues when it's an open because, again, it's hard to give the board legal advice because there's no privilege to it. And that's one of the difficulties with the Littleton provision is that in giving you legal advice, the normal rules for lawyers and clients is that your request for legal advice and the legal advice we give is privileged. In fact, I cannot ever disclose the legal advice I've given to a client. And the client can waive the privilege, I can't. Literally, and as long as I'm alive, I have to hold that privilege. But because of the way our charter is worded, since it's in public, you're essentially releasing the privilege by asking the questions. So what your outside lawyer, if I was your outside lawyer, what I would just tell you is that you need to recognize it may not be in your interest to release that privilege, but the way our charter works, you just need to know right up front you're releasing that privilege.
I mean, so that kind of happens in our hearings anyways. If we're there and we haven't consulted with our legal before, then when we're in our public hearing, essentially, or not our public hearing, but our meeting, that's open. So any advice that we request at that point is then
it's open
public.
Yes, because again, what would happen in many cities is if they had more of the state statute type of executive session, if there was something that was a contested matter, it usually will be on the agenda, an option to recess and get legal advice outside the public meeting. That's simply not permitted under the Littleton Charter.
Okay, because that would make sense. But if we were to do that, then that would be a public meeting because there would be more than 3 of us present. And therefore it would then mandated the public hearing, correct?
Well, the executive session would just have to be, it would be mandated that we show that on the agenda, and we would. If we had that right under the Untitled Charter, what you would just notice on the agenda would be, you would notice that there would be an item saying executive session, and it would specify the exact purpose of the executive session and what was going to happen in the executive session. You would then leave the dais. You probably would come over to this room. The doors would be locked. We'd have the discussion, and then you'd come back in and go on the dais.
But we cannot do that currently.
We cannot do that under the
Okay.
Untitled City Charter.
Okay. I guess that was my question.
I guess I just don't understand that either, because if you were sitting there in our last meeting and you had already, been working with the planning staff, and we had a question with regard to, either law or whatever else, then if would it abrogate the attorney-client situation with the planning staff if you were sitting there and we asked you a question, and then you could answer that?
Well, if you ask it in public, it negates the privilege, because you're essentially, as the client, allowing other people to hear it.
Even though you do have a previous relationship with the planning staff, and you've already gone through that.
That
Well,
wasn't
It would be with the other
enough.
attorney. It would be with our attorney. So
Yeah.
Brennan was representing us.
Yeah.
We couldn't ask him the
No,
advice.
if you'd ask me a question, I would just say, no, member of the commission, Mr. Dittman is your lawyer. I can't really answer that question. You need to refer that question to your lawyer.
But under
And that
regular
happened at the meeting. I mean, when you had questions for
We did ask.
and I
Yes.
remained silent. So, so that was sort of a rare situation that you probably won't see often.
But on regular cases, they can ask the attorney.
Yes.
Who's been working with staff.
There's lots of cases where there's no conflict because there's no adverse matters. It's just a case that's come before staff. The applicant has no counsel. It's not a contested matter. There, we're going to represent the board. We're going to represent staff. It's when we get an adverse where we clearly know that the other side has counsel. We've been representing staff. At that point, that's when we're going to say, okay, we need to get separate counsel for the board.
Well, we did. We did have separate counsel, but we didn't. I guess we weren't aware of it because it was unique to our experience. We weren't aware until we entered the meeting. If prior to the meeting we had questions, could we consult with counsel?
Absolutely, you could have.
Independently or individually?
Individually, you could have gotten with him, and we're going to make sure from this point forward. I know one of the practices before I came here was apparently this was not done on a regular basis. I'm not going to point fingers at any of my predecessors. That's not appropriate. I would just tell you it's very clear in the ethical rules. This is the proper way to handle it. So this is the way it's going to be handled because that's what the ethical rules require. And so, and yes, what we will do is we will make sure that you're aware that there's going to be a separate counsel. We will provide you their contact information so that you can get with them and talk with them.
Most of the time, I don't think it's really an issue, but we did have one case where it was unique and a little tricky.
And I will say one other way that you may receive advice from either myself or an outside attorney is a confidential memo. So we may write you a memo, and in that case, you would not discuss that in the meeting, but that would be a way to relay confidential legal advice to the board in a way that wouldn't be you wouldn't be violating that privilege because it would be just a confidential memo that you would not discuss during the meeting.
And that memo is privileged.
Yes.
In fact, the only entity that could waive that privilege would be the city council. So if you received a confidential memo from either Lena or myself or your counsel, that is a matter that is privileged, and each of you have a fiduciary duty to each other to maintain that privilege. As I said, the only way it could be waived is if the city council authorized you to waive that privilege.
City government is paying for our council. Is there any limit on how long we can talk to that council?
No, I mean, my view of it is they have an ethical obligation to you to provide and answer all of the legal advice and give you all the legal advice that you need. Now, if I thought an outside counsel was incurring inordinate amounts of bills, they and I would certainly be talking about that. But I can tell you, in the time I've been here, I have not come across any of the outside lawyers that the city has used that I have felt have incurred an inordinate amount of bills. I know what's inordinate, and I know if I started seeing things that I thought was really inappropriate, that council and I would have we would not get anything that they did for you, but we would have a discussion on their billing practices and what my expectations would be on their billing practices. But when we provide you an outside counsel, we basically, the instructions for me is you are to provide all of the legal advice and legal services that board needs as they request. We don't impose limits and say, well, you can only spend 2 hours. If you need 8 hours of outside lawyer services, you get 8 hours. They provide whatever you need.
And the respondent that comes in for the appeal, I'm not aware of the process for that. Do they have to state earlier than the meeting that they're bringing a counsel with them?
We try to work with them so that we know. I mean, I would tell you, if they showed up at a meeting with counsel and that was the first we ever knew, that creates a huge issue, because now we have a meeting, we can't represent you, we've been involved with them all the way along, and we can't just call them up on the phone and say, race on over here. We probably at that point end up having to continue the meeting. I would tell you, most of the lawyers, both here and previously when I was in Arizona, I don't think I ever had an experience on a Board of Adjustment case where somebody surprised me and just showed up with a lawyer. Could have happened? I'm sure. When you say never, never usually gets overcome very quickly. But I have not had that happen in my experience.
Using the term continue. When we had our previous training, it was called tabled.
The reason I use continue versus tabling is, and the City Council Rules of Procedure kind of confuse this a bit. Normally under Robert's Rules, when a matter is what they call a table, the technical term is to lay on the table, the matter is ended until it's brought back. Where continued, the matter is simply carried over to another meeting and then comes back. I don't like to use the word table because it conveys that impression from Robert's Rules that we're basically just shutting the matter aside and it's not coming back. It is coming back, it's just being carried over to another meeting. So if you look at Robert's, now the city doesn't use Robert's Rules, it uses sort of an abbreviated set of rules of procedure where it uses that term table. And it kind of uses the two terms interchangeably. Certainly one of the concerns I would have is a city council without waiving any privileges is that table and continue really mean two different things.
On that note about the attorneys, there was a case, and I don't know if staff was aware or not, but the attorney actually came in with the person seeking the variance and basically presented on their behalf. They weren't really. There was no adversarial feeling with that, but basically it was his attorney presenting for him.
Well, we're going to be talking about that very shortly when we talk about quasi-judicial, because one of the difficulties is, and we'll talk about what quasi-judicial is and why I would tell you attorneys don't do a good job of this. when attorneys come before you in a quasi-judicial proceeding, they're not testifying. They're just basically giving you their legal argument. It's the applicant's testimony that counts, because the attorney's just giving you legal argument. And I've seen a number of quasi-judicial hearings, even here, where this gets really convoluted. One of the things we're going to be doing is we're going to be bringing probably later this year, early next year, to the council proposal for a set of rules of procedure for all quasi-judicial hearings in the city, so that we actually have a process. Because the thing in a quasi-judicial hearing is you're basically the judge. Now, if you have ever talked to a judge and say, "Judge, how would you like to do a trial without any kind of rules?" A judge would go, "Oh my goodness, I couldn't. It's impossible." Yet that's kind of what we've been asking you to do. And most cities that have quasi-judicial processes have rules of procedure for that, so that you kind of know, and the litigants know, and in this case the applicants know, here's how the hearing's going to be done, here's what the rules are, here's how it's laid out, and everybody knows what the rules are. And those will be coming.
I wanted to answer your question, Jack. The appeal came through an attorney's office for this latest case.
Okay. What I thought, but I can see some disgruntled respondent coming in and having counsel with them. That's why I asked, what should we do? Wait.
So continuing with talking about the different roles of things in the city, so very briefly the role of the city charter and the city code. So the city's charter is what we would liken to our local version of the Constitution. It is going to establish the framework for governance of the city, and our city code is what sort of equal to our local statutes, and it's going to establish the law and policy in the city. As you may know, the city of Littleton is a home rule city, which means we can't enact laws that differ from the state unless we've been preempted from doing so by the state. And it gets a little complicated, so I'm not going to go into too much detail about what preemption can look like, but just to know that we can differ if the state has been silent on a topic. So you will maybe notice that in, I don't know if you ever have noticed that, but you will notice sometimes that our laws may differ from the state. So, was there anything you wanted to add to that, Steve? Or
No, I mean, most of what we do pursuant to our home rule charter. A good example of preemption is a recent case that came out of the Colorado District Court for Jefferson County. There was a charter initiative in the city of Wheat Ridge, and it dealt with urban renewal authorities. And there was a lawsuit, and the district court said, listen, there's certain areas of the urban renewal law where the state legislature has said, this is going to be the standard across the state. Doesn't matter that you have a home rule charter, the state legislature has said, this is the way it's going to be for everybody. General law cities, which are cities that are governed totally by state law, or home rule cities. And when the legislature does that, that answers the question.
follow-up questions on the last slide before we move on? So now we're going to shift a little bit into meetings. And I'm going to move fairly quickly through this because I know, as mentioned earlier, you have had a fairly comprehensive training on meetings, but just a little refresher. So just start by talking a little bit about effective meetings. As I hope you are aware, all authorities, boards, and commissions in the city are governed by the City Council legislative rules. As members of the Board of Adjustment, you are responsible for reviewing and understanding this document. You can find it on the website under the City Council tab, or you can ask your friendly staff and they can provide you a copy. If you have any questions about it, please let us know. As we've mentioned a couple of times tonight, the legislative rules that the city follows are a more relaxed version, based more or less on Robert's rules. I do not suggest ever trying to read Robert's rules. It's a rather dense... Yeah. But it follows generally that same philosophy, but not exactly. It's going to be a little bit, like I mentioned, less formal. So I'll go over really briefly the stages of a meeting, but like I said, I'm going to kind of move quickly through this topic. As a general rule, there are two stages to a meeting. There's your fact-finding stage and your deliberation stage. You, I'm sure, are aware of this. You deal with this every time you have an issue come before you. The fact-finding stage is going to be the stage where the staff, the applicant, and any other interested parties are going to present to you. And at this point, you should be keeping a fairly neutral fact-finding mindset and asking only clarifying questions and really attempting to avoid taking any positions during this stage. The next stage, like I mentioned, is the deliberation stage, and this is going to be your decision-making stage. This is going to be when you can make statements of a certain position, talking about how you believe the facts lead you to a decision, and that would be the appropriate point to talk about it. Any follow-up on that?
Yes.
Do you have...
No, I don't have anything else.
Okay. Any questions? So we will talk a little bit about the quasi-judicial role. So we talked earlier about wearing hats. So this is your judge's hat. As you can see, your nice wig. This is going to be the role when you are, like Steve mentioned, basically acting as a judge. The board itself is in a judge capacity, and all of the rules that come with that role. So you're wearing your quasi-judicial hat, or wig in this case. So particularly this is going to be when you're doing appeals, such as signs and tree removal, or variances.
And in those cases, because you're essentially making a determination of both facts and law, you're in this quasi-judicial role. And what becomes important is just like with any judge, there are a series of requirements that must be followed in this quasi-judicial role. And the first one is that you are limited to considering what is on the record before you. Unlike other roles that you will have, in a quasi-judicial hearing, if it's not in the record, you cannot consider it. And so, the record, what's the record? The record is all the staff reports and staff documents submitted. Any document that is submitted by the applicant as an exhibit, all of the testimony from the staff and the applicant, and any comments from the public that were made at the meeting. Those are all part of the record. What you cannot do is, I'm in Safeway and somebody knows I'm on the Board of Adjustment and they want to talk to me about a case. That's not part of the record. That can't be considered because it's just like with a judge cannot consider any of that. In fact, the judge and you are basically obligated to tell that person, I'm sorry, this matter is coming before me. I understand you may have concerns, but I cannot talk to you about this because it's a quasi-judicial matter and you're functioning in that role.
Hey, we're human beings. I drive down Santa Fe every day. I saw anglers fishing shop every day. They came in for a sign variance. I can't take that out of my mind.
And you're not required to, just like a judge who hears a case, they have all of their life experiences, what they see, what they know. They can't take that out of their mind.
And they may live in the community. Obviously, as you do, live in the community that you sit on the board for. So you are not required to live in a bubble, but there is an understanding of what would cross the line into ex parte or something that's not a part of the record, and then there's just life. Obviously, you can't avoid Santa Fe. You're going to drive past that sign, and we're not suggesting that you won't. But should you have been in the store and the applicant cornered you by the fruit and vegetables and started talking to you about the application, that would cross the line into not acceptable versus I can't avoid driving down Santa Fe. So you're always going to have those life experiences that factor in, but there's a difference between that and something that is not appropriate in a quasi-judicial setting.
So if we're looking at a case, and we're reading it, and we got the staff input, and and we're prior to taking a look at coming to the meeting, if we go and take a look at the property, or we're driving down the road and we happen to see the sign, and we realize that that they're asking for a sign on the other side, and it turns out that it's at night, and you can say, yeah, I can see that. That makes sense to me.
What my recommendation would be, obviously, all your life experience you bring with you, just like any judge does. Now, if you're going to do a site visit intentionally because you want to see the site, then my recommendation would be the night of the hearing, you simply disclose that for the record. I'm Commissioner so-and-so. I did have occasion to go there at a site visit. Obviously, I would not go with the applicant or anybody else. I would just go by myself. I did go there on a site visit, and I did see the site. And I just want to disclose that for the record. Now that information's in the record, and clearly you are able to consider what's in the record. And obviously your day-to-day life experience, we all have those, judges have those. I mean, I've tried cases in front of a judge, and a judge will say, counsel, just so you know, I drive by that corner every day where the accident occurred, and my response is, of course, that's just life experience. And most judges would generally say, it's not going to color my view of the evidence in this case. I just happen to drive by there every day. That's life.
Now, I could see situations where it could color if it's, say, an issue with someone that's your neighbor or in your neighborhood, and it's could somehow color your judgment.
Yeah, and if you have those situations where, again, as a judge, you have outside evidence that colors your view, then the appropriate thing is to recuse yourself from the matter and just say, I have outside evidence that is not part of the record. It has colored my view. I don't feel it's appropriate for me to participate in this matter.
Well, you gave us a key example that I think mitigates what I've heard before, because I like to do site visits, and if I disclose them, I feel very comfortable doing that. I felt in the past we weren't supposed to do site visits, but if we can do site visits on our own with a disclosure, that makes me feel a lot more comfortable.
I think you can do that. Now, I would tell you many times, a commission might want to say, gee, we as a body want to all go together so we all have the same information. If you want to do that, then the appropriate thing would be to contact staff. Staff would arrange for that, and you would all go. That would obviously be agendized. And again, because you're judges, what normally happens is the applicant and or would also have a right to attend. They couldn't talk to you or anything, but they'd have a right to attend. But if you individuals go, my advice to you would be that you should then make sure you disclose it in the record, so the record just indicates, yes, I went and saw, I walked around this, and I did see the site, and I want to disclose that for the record.
Well, I think what gets tricky sometimes too with what's in the record is, say we're looking at a sign variance, and it's technically a variance for square footage. And the applicant shows up and they start showing all these pictures, and it's really easy sometimes to get off on, you know, colors or design or whatever, but we're really only allowed to rule on square footage. And that's really, unless somebody, so I guess my question is, that's what we're there to rule on, is square footage, regardless of whether we like yellow, red, blue, whatever it might be, or not. If somebody in the public then brings forth, well, I'm fine with 300 additional square feet, but I don't like these colors, is that then part of our ruling? Or because it's at the record?
Well, many times the public will testify for things that are outside the board's authority. And what the law basically says is that you're going to give that testimony whatever relevance you as a judge feel it's worth. Now, if you feel that this testimony is well outside the board's authority, it's perfectly appropriate to say, well, because it's outside the board's authority, I'm not going to give it relevance because of that reason. And it's just like many times testimony will be gotten out of a witness in court, and the judge will say, well, I'm going to let it in, but I'm not really going to consider it because I don't think it's relevant to making a decision on the issue. And you function in that same role. The testimony may be there, but it's perfectly appropriate to say, I don't think it's relevant to our decision on the issue.
So isn't one of our considerations often, like, does this variance affect the essential character of the neighborhood? And that seems like a pretty vague concept.
However, if what's being brought forward is a variance on square footage, I would argue that what you should be considering is if providing a variance on the square footage would affect the character of the neighborhood.
Right.
So trying to focus in on what the variance is asking for. Now, if the variance is asking for, I don't know that we would have one asking about color because it's not something that we regulate, but just for example, if it did, or if you had one about lighting, which you have had about illuminating signs, then when you're taking those, things like the requirement that it doesn't affect the character of the neighborhood, then applying that back to what it is that the variance deals with. So if it's lighting on the sign, if it's square footage on the sign, would providing that variance affect the character of the neighborhood?
Okay, but when you're talking about the neighborhood, and it may be not my neighborhood, it's somebody else's neighborhood. If I don't go to that neighborhood, then who do I rely on in saying it is or is not consistent with the neighborhood?
Well, you would be relying on the staff testimony, you would be relying on the testimony of the applicant, you would be relying on the testimony of any citizens that come to speak at the meeting, and should you have gone and done a site visit and disclosed that, you would be relying on that experience as well.
And essentially, at the end of the day, it's that record in front of you that you're going to look at in making your decision. And I mean, as someone, I've been an arbitrator, which is basically a fancy word for a judge one time in a case. And I have to tell you, in most cases, there's a certain degree of frustration because you're sitting there going, well, I wish that they would have addressed this. They just don't. So I'm left with the record I have in front of me. Which is why your job can be very difficult, because you're sitting there going, I wish this was in the record, and it's not.
And yeah, you can ask clarifying and fact-finding questions as part of your role.
Absolutely.
And you can ask them of the applicant, you can ask them of staff, and then that would be in the record, the answer to those questions.
And we can ask them of the public that's giving testimony.
In a public hearing, when the public is testifying, yes, you can ask the member of the public questions regarding their testimony.
Does that count towards their 3 minutes, or is that something added on?
Well, that normally would be, again, because the meeting's being videotaped, that would become part of the record. Now what happens is, obviously, and this gets a bit difficult, because many times you'll have the public giving testimony and it may not be relevant and to the matter, it may be outside the statute and the basis for your duties. But okay, in many quasi-judicial hearings, the public will say something, and yes, a council member will may have a question about, what do you mean X? Or a commission member may have a question about, do you mean X? Your questions to the public aren't to be argumentative, just like when a judge does a hearing, if a judge asks a witness a question, it's usually because the judge wanted to make sure that I understand what this witness is testifying to.
Since the public has 3 minutes, does the question take up their time, or so let's say their 3 minutes is up and then the board has questions of them, that wouldn't contribute to the 3 minutes of the time of the public testimony, correct?
Yes, I mean, when in a public hearing, what would happen is that normally if the board has a question, that's not going to usually go against the time that the individual has. But your questions as a judge really need to be focused on simply, I want to make sure I understand your testimony. I mean, as a judge, I've had where somebody would testify and it's like, I don't think I understand this. I need to make sure I understand exactly what they're saying. Because it's now part of the record, I want to make sure that I understand it.
Question about variances. I know that I've asked this in the past and not really comfortable with where I'm finding myself. But with regard to variances, I've always taken a look at you look at the case and say, yeah, it makes sense for this case. Now, if, say, for example, we know that there was a case 3 months earlier or something like that that was basically very similar to it. However, is there any place for say, having some type of deference to an earlier decision?
So your decisions as a board are not precedent setting. So that means that one decision does not affect another decision, and you should be looking at each individual case as its own individual situation, and not considering a past variance that you may have allowed or not allowed. You should be really focusing on that particular situation.
Sure, I certainly understand that, but I always look at it this way and saying, if I were coming in as the person asking for a variance, I could look at it and say, well, gee, the board allowed this, why can't I have something similar to this?
And I know what you're saying. I mean, as Lena mentioned, because each case stands on its own record. Now, the purpose of a variance is because the strict interpretation or application of the code results in a hardship. The classic example I had from a prior place I worked, there was 10 houses on a street. 8 of them all built patios into the setback. Why raise your building permits? Go figure. Number 9 comes and argues to the board. Listen, there's 8 patios here already built into the setbacks. It is a significant hardship if I'm not able to have my house compete with those 8 houses that have patios. Won't you consider granting me a variance? Now, I have to tell you, I made the argument from the staff standpoint is the fact that we did 8 things wrong doesn't mean that it's a hardship. It just means the city did 8 things wrong. And that doesn't mean we should repeat it for number 9. But I understand where the applicant was coming from, which was that was part of their argument for a hardship. And that's what makes your job very tough, because you're sitting there going, well, 8 people already have patios into the setbacks. What is so wrong about number 9?
Right. So,
And that's where you are going to have to make that legal judgment. Does that rise to the level, based on the record, of a significant hardship resulting from a strict interpretation of the zoning code?
We have had a couple of cases where, when you grant a variance, if it requires a building permit, they have 24 hours to build. And there have been a few cases where, for some reason or other, it was never built. And then the new owner or that owner that, allowed it to lapse has come back before the board again. But when they do that, it's still not a precedent, even though it was their own case, correct? They still need to prove it on its own merit.
Absolutely.
Okay.
We have, just like in the state, we have what we call courts of record, and we have appellate courts. The district court is what we call a court of record. Office decisions are done with court reporters. There's a full record. But their decisions are not precedential. The fact that you get a ruling in district court, there's nothing that prevents the district court from making a 180-degree turn going the opposite way tomorrow. The 2 courts that are what we call appellate courts, who are bound by their prior decisions, are the Colorado Court of Appeals and the Colorado Supreme Court. You're like the district court. Each case stands on its own record.
Where does it state that it is non-precedent setting? Is that a state statute, or is that a City of Littleton statute?
That is just basically the way that the board is designed in the code, because the courts that are precedent setting have reported decisions which people can look at. For example, I can go in and look at every decision of the Colorado Court of Appeals. So the courts have adopted as part of their court rules that those 2 courts, their decisions are precedent setting. Now, interestingly enough, if you were in Florida as compared to Colorado, in Florida their district courts are precedent setting, and they actually report all the decisions out of their district courts. We don't here in Colorado, and that makes a difference.
so then really, an applicant or something like that really is a crapshoot for them. They can't say, well, geez, because we have those 8 other houses that that should, we should have some leverage or some ability to be able to use that as a going in position, or if otherwise they're just saying, oh, geez, this is just crapshoot, and I don't know where we're going to go. There's no way to really either predict or to understand how the system's going to work for them.
Maybe the 10th house gets its variance.
Yeah.
This is out.
Right.
Well, and you have to understand that you could, because you're looking at the record as it is, you could have different facts on house number 10 than you did on house number 9. And that's, just the way it could go, is that you could have things that seem very similar. You could have 2 neighbors that both come in for fence height variances, but the record is different for neighbor A than it is for neighbor B. And that's why you really have to be looking at just the record for that case.
And you could have very similar facts, but the standard being that you have to show that there's a significant hardship arising out of a strict interpretation of the zoning code. You have drawn a different conclusion on very similar facts involving 2 different cases. I have had that happen many times. And that's just the way our process is designed to work.
So you had the Carmelite nuns, you know,
Yeah.
and then, so the person right next door might want the same size fence that you guys granted. Well, the two totally different situations based on the unique situation on each lot. So that's an example where you wouldn't grant the same variance for the same height necessarily because it was a different situation.
Okay, well, that's...
So we'll go through this pretty quickly because you had prior training. And as Steve mentioned, we are working on bringing forth to council a more formal version of our quasi-judicial and meeting procedure guidelines. And at the time that that happens, we will be sure to bring those to you.
And then we'll basically sit down with each board and spend some time going over those in detail.
So I'm going to do this at a fairly breakneck pace, but don't be alarmed because hopefully we'll be coming back to you again. So really briefly, different parties in a quasi-judicial proceeding. There's the city, there's the applicant, and there's also staff in there too. Things to consider before a meeting. We talked before at quite some length about ex-party communications.
Question. You send out notices via the internet on the Littleton internet net. And is the notice officially given to me when Pam sends it out? Or is it when I read it about 5 days later because I forgot to look at my emails?
Notice is when it has been posted. And we post in several locations. We post here at the city building, we post at the courthouse, we post the library.
And then also on the website.
And also on the website.
One of the things we're going to be working on as part of our rules will be that whenever we get a quasi-judicial matter filed, that we will be sending to that respective board right up front. Board, we have a quasi-judicial matter that's filed. We want you to put you on notice now. The quasi-judicial guidelines apply. If somebody approaches you on this, don't talk to them. Now,
This is regardless whether the meeting has been set yet.
even though the meeting's not been set yet, what we want to do is our goal is going to be as soon as a quasi-judicial matter is filed, to let that board know, because the worst thing is to have you get involved inadvertently in an ex-party communication.
And in the case if that happened for some reason, if you didn't get your email and you somehow didn't know that something was coming up and somebody approached you and started talking to you about it, I mean, I think that probably you might start to realize that maybe they were talking to you about something that you shouldn't be talking to them about. If they start saying, you know, I have an application for a variance, that's probably like a ding, 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 like, you know, I should extricate myself from this conversation. If it's not apparent and then you find out later that, you know, your neighbor came, you know, somebody who lives in your neighborhood came up to you at a block party and started talking about something, you didn't know that they had a variance application, turns out they do have one. You know, that's the situation where you come to Steve and I and you say, here's what happened, what should I do? And depending on what happened and how much you discussed and how that conversation went, we may say to you, our advice to you is that you recuse yourself, or our advice to you is that you simply disclose that before the meeting starts. So that's going to be a case-by-case situation.
Instead of following on what Jack just asked, then really what you're saying is once notice has been posted, okay, rather than received, because
Yes.
you know, I might receive it you know, a week earlier, and he might receive it a week later, and in that period of time, you know, I'm walking around and not talking to anybody, and somebody else is approaching him.
But isn't it actually before even the notice is posted?
Yes, our goal is going to be, and that's why we're coming up with a form that we're going to be providing, is really, once the application's on file with the city, it may be 6 months before it comes to you. But once it's on file with the city and we know it's going to be a variance, we know now it's a quasi-judicial matter. And one of the things we need to let you know is, we have an application. It's a quasi-judicial matter. Here's the subject of the application. Here's the parties. If you get asked about it, don't talk about it because it's a quasi-judicial matter. It may not be coming to you for a while, but it's coming to you.
Right, and we have about a 5 to 6, at a minimum, 5 to 6 week lead time for applicant submittal before you guys actually see it. So that's the minimum. Sometimes it takes longer than that. So, but we're formulating a report and trying to get that out to our boards and commissions so that everybody can see this, ahead of time. It applies to Planning Commission, it applies to City Council, it applies to Building Board of Appeals. We're trying to get those things out. Historic preservation.
Yes.
So.
So we talked about this a little bit before. Obviously, you need to try to remain fair and impartial decision makers, which is one of the reasons that it's very important to avoid ex-party communications or anything that could color your ability to be fair and impartial. We touched a little on disclosures. Disclosures could be ex-party communications. It could also be personal connections to the case, to the applicant, something that could color your judgment and your ability to be fair and impartial. For example, the applicant is my uncle. Could be a problem, could not be. That's going to be one of those judgment call things.
And sometimes you as a judge, I tried a case involving a towing company, and the judge looked at all the lawyers and said, I need to tell you something. And it's like, okay, Judge. He goes, my wife works for a towing company. It's not the one that's the subject of this litigation, but I want you to know my wife works for a towing company. If you feel there's something like that that may raise a question about your ability to be fair or impartial, you can come to us. I may well say, no, it's not a conflict. You may say, well, can I disclose it on the record? My response would be absolutely. None of the lawyers in my towing company had a problem with it. I didn't have a problem with it. Did I feel good about the judge disclosing it? Yeah, I did, because it just made it clear. It was out there. No one had to wonder about it. End of discussion.
And as we discussed previously, you all live in the city of Littleton, so you may cross paths with these applicants, you may have some connection to these situations, and you may work in fields that are, there may be an architectural company and you may have, somehow connected or cross paths with them. That stuff's going to happen. So it's just about being upfront and making sure that you are able to be fair and impartial. And that's the whole point of making those disclosures. And that's exactly when you would use the resource of having Steve and I to ask us and to talk to us about, hey, I feel like this could be an issue. What do you think? What should I do? And we will walk you through that.
And those disclosures can be made right there at the meeting. Right?
And that would be our suggestion, is that before things get started, you just say, I would like to inform the board that I have X, Y, and Z connection. I don't feel that this rises to the level that I need to recuse myself. I just want this to be on the record, and then you can proceed. If it is to the point where you feel like you need to recuse yourself, that's also the moment where you would say, I have X, Y, and Z connection to this. I feel that I cannot be fair and impartial, and I am therefore recusing myself.
And at that point, you actually need the dais.
Yep.
You can take a seat in the audience, but you actually need the dais.
And it could happen that you have multiple variances on one night, and you only have that connection to that one, so you would recuse yourself, step off the dais, and then come back for the next one.
And that recently happened with Planning Commission, where there were multiple cases on the agenda. One of the Planning Commissioners stepped down for one of them and then came back for the other.
If you step down and you're sitting in the audience, can you sign up to give testimony?
No.
No.
Because you have the roles, in essence, as a judge, and even though you've recused yourself, you cannot then give testimony.
You are not now a private citizen.
You can't act as a judge, you can't give testimony either.
No. No.
So how,
Let's try.
if we want to appeal something against the zoning code individually,
You are going to then have to be, most likely, because that would be totally incompatible with your position on the Board of Adjustment, you're going to have to resign from the board.
okay?
So I'm going to kind of skip through this slide. So excuse me for being fast here, sorry. Whew. Okay, so we're going to skip forward to your to the legislative role, and this is your legislator's hat. So you will notice that this slide is blank, and the reason for that is that really, as the Board of Adjustment, you do not have a legislative role, and you're very unlikely to be wearing this hat. But we did want to bring it up and make you aware of this role does exist for some boards.
Literally, the only time you might exercise sort of a legislative type role would be, for example, I expect someday we will bring forth an amendment to the Board of Adjustment section of the city code, because it's neither consistent with state statute, it has a lot of issues. That would be something that we would bring to you and talk with you about. That would be the type of thing where you would be acting as a legislative body.
But for example, like Planning Commission actually has as one of their
Rules by law.
rules by law is that they will provide recommendations to City Council concerning the code, concerning the zoning code, and it's same with HPB, with the Historic Preservation Board. So in that sense, they are acting as legislators when they're presenting those recommendations to council. The last role that you could have is the regulatory role. This is your Smokey the Bear hat. You would be doing this when you're doing your review of zoning interpretations. Deference is given, in this case, to the zoning administrator's decision. In this case, the zoning administrator is Jocelyn. With something like this, we've talked about the standard before, but it's overturned only if clearly erroneous. So the standard, it's a fancy legal term because we lawyers like our words. It's arbitrary, capricious, and unreasonable. And Steve can walk you through what that means in non-lawyer speak.
What this is that you're essentially acting as the review body for an agency decision, in this case, the zoning administrator. It's much like on the state basis. The state has administrative bodies that review state agency decisions, and if you go to the federal government has bodies like the Federal Trade Commission that review federal agency decisions. And when you do that, there's some basic rules of law. The first one is deference is given to the agency's decision. The agency is considered to have expertise in this area, and that there's deference. And that means that essentially, all things being equal, if everything was just absolutely perfectly equal, deference is going to weigh in favor of upholding the agency action. Now, the standard for review is, it's a nice long legal term, arbitrary, capricious, and unreasonable. Let's forget the legalese. Let's get right down to what that means in reality. Arbitrary means a decision that is unthinking. You didn't consider anything. You just rendered a decision. Forget the record, forget the evidence, you just did it. That's arbitrary. Capricious means that you just did it without hearing any evidence. You just came in, we're going to be here for 2 minutes, we're going to render a decision, and we're going to get the heck out. That's capricious. And unreasonable means that no reasonable person looking at the facts in front of them could come to this conclusion. That there's no way any reasonable person can get to this conclusion. And so the law looks at that as the standard. And what that means is is that a zoning administrator decision, all things being equal, would be upheld. But let's just say the zoning administrator, and I actually had one of these, which not here, but in a city where the zoning administrator had to render a decision on the meaning of a provision in the city code on how you calculate setbacks. And the zoning administrator took the position that you calculated it from the center of the street to the building. There was no way you could read the city code that way. It was impossible. And I said to the zoning administrator, you can't read the code this way. The code says you should calculate it from the right-of-way line. Well, the right-of-way line is the center of the street. No, it's not the center of the street. And the board overturned that zoning administrator's decision. They just said, that was an example of an arbitrary decision. You simply could not get there.
So it can be any of the three. It doesn't have to be all three.
It can be any of the three. And so I would tell you, certainly from my standpoint as a lawyer, and rendering legal advice to a client, I mean, if I had a zoning administrator here who was going to render that kind of decision, let's just say the lawyer was extremely animated in that when I was in that city. I mean, it was like, you can't do this. It's like, I'm going to do it. And I was like, well, I'm telling you, when it comes in front of the board, I'm going to have to lay out the standard, and the board's going to have its lawyer, and the board's lawyer is likely to say that this qualifies, and the board's lawyer did. And that is what the meaning of that is. Now, the important thing about knowing in this role is unlike under our code, a variance and an appeal is a matter that has a public hearing. There's a right to take testimony at those items. This is a general business item. It's not a public hearing item under the code, and it's a general business item because you're reviewing an agency decision. You're not basically adjudicating rights the same way that you are in a variance. And that's what makes this different. One of the things I get with counsel is this gets confusing. This one has a public hearing, this one doesn't, and that happens with any quasi-judicial body. That there will be times when you wear these different hats. In these different hats, it's hard for the ordinary citizen to understand that when the board's wearing different hats, that may decide whether there's a public hearing or whether there's not.
So all the regulatories would have multiple councils. One for the board, one for the city or whomever.
Usually there's going to be separate counsel because I would tell you normally by the time you get to a zoning interpretation, I've had
been providing advice to staff, and particularly in this case, we likely have been walking through this with the zoning administrator, or in this case, Jocelyn. So very likely we've been providing legal advice to staff for quite some time. So it's highly likely that in this situation you would have outside counsel.
And quite honestly, and as cities get more sophisticated in zoning, in the last city I was in, we probably did a couple of zoning interpretations a year. I know it was a relatively new thing for you because the city had not done one in a considerable length of time. My guess is you're probably going to see more in the future because particularly as the zoning code is made and developed into what I would call a more citizen-friendly code, that comes up. And with that, I'd be pleased, and Lana would be pleased to answer any questions that you might have.
I think we covered quite a bit in those slides.
Is there anything the board would like to have training on from Steve or myself in the future? You certainly don't have to answer that question now, but that's something you can percolate on, and if there's a particular topic that you would like to expand on or a new legal topic you'd like to have us bring as a presentation, we'd be happy to do that for you. So if that's something you want to think about and let us know, you can certainly let staff know, and then we can discuss that.
You know, I know that the planning board does a great job of trying to do the research and provide us with what statutes or what codes or whatever apply, and sometimes it's hard for me at least to be able to say I draw from what the code says to what the case is, and what the standard is or the criteria is. And I don't know if it's a problem with the code or if it's just me, but I just have sometimes a difficult time looking at maybe have 3 or 4 different codes that seem to work at different levels and they contradict each other, or they go in different directions.
Yeah, no, I would tell you one of the things that I really want to work through is my preference for code is it says this is what you do 1, 2, 3, 4, 5. So an ordinary person can look at it and know, oh, I do 1, 2, 3, 4, 5. I'm good to go. I wish I could say our code was that way. It's not. But as we work through it, one of our goals is to help create a code where a board doesn't have that kind of problem that you were talking about. Because quite honestly, I have that kind of problem as a city attorney. I'm looking, a good example of signs. Where in every other city in the United States I'm familiar with is the sign code, it's part of the zoning ordinance, except in one city. Middleton, Colorado, is part of the building code. Nobody who's coming in for a zoning package which involves signs would ever think of going to the building code and looking for the sign code.
So
But that's where it is.
Make it clear. But well, it's more than some. There's a lot of things we need to clear up to make it clear for everyone. And not just for what you guys do, but HPB, Planning Commission, the zoning regulations, the subdivision regulations. All of it needs to be cleaned up. It's an older code from like 1972. Things have changed a little bit since then.
Yeah, and that's, when you start looking at some of that and you say, well, I don't quite understand why and how, and how does that apply today, and a little bit of clarification would really be helpful in the advanced package that we're looking at.
So we're working on also trying to make sure our staff reports are a little more complete. We're including in the Planning Commission stuff, and we can include that in the Board of Adjustments package where we say this is a quasi-judicial matter, and we're trying to kind of guide based on these trainings that we've been rolling out for everyone, that we're letting everybody kind of know which hat you're wearing. So remember your hats. We won't say in the staff report, wear your wig and wear your hat. We're not going to say that, but it'll we're trying to put in there that in what the purview of the board is, or the Planning Commission, or So we're working on that.
Graphic in the corner.
We are suing you all for wigs. I'm just kidding.
We wanted, I joked that maybe we should put it on our presentation that it should be over in the corner all the time, which hat. But no, that's not what we're doing. But we're trying to make it more clear, and this is what your role is. These are your choices. You can continue, deny. You can approve with conditions, things like that. We've been working on that with the Planning Commission and City Council.
Which is one of the reasons why we're doing the very thing we're doing tonight, is to give you another piece to this, so that you're able to be as effective as you can. We're upgrading the staff reports, we're working on different things in the code, we're also providing, quite candidly, a lot more legal advice. There's been memos that have gone out to the Planning Commission on different items, and one of the goals I have is as the city's lawyer, is to make sure that every board, whether it's from Lena, myself, outside counsel, that you have all the legal services you need. So there's sort of a comprehensive, in a lot of different directions, things being done. So, and it's a work in progress. But we have a very close working relationship with the Community Development Department in terms of how making sure we are doing business in the most effective and efficient means to let you do your job in the best way possible.
We're trying to mirror the presentations to match the staff reports, so we're walking through them, we're improving. I mean, we're working behind the scenes feverishly to try to make it more clear and transparent for everyone.
I appreciate that. I mean, I think I've noticed changes over time, and you know, our goal. I appreciate the help because we don't want to get anybody in trouble. I mean, we want to know. I think clear rules are important so that we understand, you know, the process and basically it's all out there how it's going to work, and we have a clear understanding so that we're not getting into some weird pickle, so to speak. And then, you know, I'd also like to add to the point on the zoning code. I mean, I stare at zoning codes day in, day out, all over the place. And I appreciate the fact that you guys are trying to clean it up and clarify things. I think that's really important. All that to be said, the zoning code can't cover everything, so there's always going to be some little nuance in there, which is why we have the Board of Adjustment, which is a great tool for citizens, developers alike.
Absolutely, and your role is critical in the administration of zoning code because the recognition of zoning really back in the time it was developed in 1927 in a case called City of Euclid has always been that zoning codes can be inflexible and there needs to be a way to deal with the fact that sometimes it can be inflexible.
As long as you don't send us any correspondence with emojis on it.
Okay.
Oh, come on.
Emojis with hats.
With the wig or hat thing, you know which one? Like this is the smiley face with the wig?
Right now.
You know,
Smokey
the
the
bear.
Bear.
Yeah. No, we were just trying, like, now it's non-linguistic representation, so now you remember quasi-judicial is this, regulatory Smokey the Bear, just...
It is kind of a unique thing. This is the only English-speaking country in the world. If you go to Canada, their judges still wear white wigs. I was in Ghana, West Africa. Their judges wear white wigs. It's a tradition of English law. You go to India, the judges wear white wigs. The only place judges don't wear wigs is the United States.
So count yourself lucky. Any?
But if you all want wigs, we'll
have a costume section in the back behind the dais.
I think we're
done.
Yeah, any further questions for us?
Thank you.
Thank you very much.
You're very welcome.
Close the study session. Is that it?